When the HOA president sued me for living outside her authority, she expected a quick legal win. She filed papers, hired a lawyer, and smiled like a victor, until 3 minutes into the hearing, when my evidence, my witness, and a courtroom twist crushed her case and handed me the judgment instead. We moved to the Ridge for one reason: room to breathe. My wife and I bought a weathered farmhouse on 10 acres, far enough from ribbon-cutting subdivisions that our days were measured by sunrise and the clang of a coffee cup on the porch. The closest development was Maple Hollow Estates, showpiece lawns, HOA signs, and a president who treated the neighborhood like her personal city council. Her name was Donna Kramer, Karen energy with a law degree and a habit of measuring other people's lives with a yardstick. Donna had shown up the first month, smiling all teeth and friendliness, then slipped an HOA welcome packet under our door. We never signed anything. Our property deed, clear as a bell, sat in the county registry, private parcel, not annexed, no HOA covenant. For a while, it was peaceful. I fixed the fence, my kids learned to row on the pond, my wife planted lavender that smelled like evenings. Then Donna's notices began. Please remove unapproved signage, tree pruning not to spec, parking violations, mostly passive-aggressive slips, a couple of stern emails. I ignored most of them. I also avoided confrontation. Community ties are messy, and I like my evenings quiet. One Tuesday morning, a man in a blazer knocked insisting on a quick chat. He introduced himself as the HOA's legal counsel and left a thick envelope. "This is just a formal notice," he said kindly. "Please take it seriously." Inside, a demand that we conform to the HOA's deed restrictions, which we never agreed to, or face enforcement. I clipped the envelope and tossed it by the kitchen sink. The next week, a certified letter arrived, a complaint and notice of intent to file suit for non-compliance with community covenants. In the signature block, Donna Kramer, HOA president. We read it twice. We both worked in fields full of contracts and land documents, so reading legalese was not foreign. But here's the thing. Maple Hollow's jurisdiction didn't and couldn't cover our land, period. The HOA had never been granted an extension by the county. There was no filed amendment, no recorded easement, nothing that turned our private deed into subject matter for their board. Still, Donna's approach wasn't about law so much as pressure. She'd bullied neighbors before, used fines like a club, and everyone on her side seemed to nod when she spoke. When the lawsuit came through, she probably expected the ubiquitous reality of most people settle. She expected we'd cave, pay attorneys, and paint the porch the color she preferred. Instead, I did the thing she never considered. I laughed a little, then I started to gather everything. My deed, the county recorded maps, property tax statements, surveys from previous owners. I pulled the HOA's filings and compared dates. The more I dug, the clearer it became. The HOA's claim was as thin as tissue. My wife suggested mediation. I suggested we let the record speak. If she wants a fight, I said, let's make sure the public sees how she brings it. We hired a local attorney who liked to be blunt. If Donna had the nerve to file in court, she'd have to prove jurisdiction under oath. If she couldn't, it would go badly for her. The day we received the summons, our neighbor across the lane, a gruff retired judge named Martinez, dropped by. He'd hosted HOA battles before and stayed out of most neighborhood drama. He read the complaint, chuckled, and said, "You want him to show up in court?" I asked what he meant. "Show up early," he said. "Bring your deeds, your maps, your witness. Bring the man who records the county plats. If she sues, she'll have to prove she has claim. Most judges don't appreciate frivolous filings." Donna thought she had it wound tight. She walked around the neighborhood sending threats, telling neighbors she was defending community standards. She told anyone who would listen she expected a default judgment unless we cooperated. People who didn't know the details nodded and worried. Lawsuits are loud, and loudness often translates to victory for the loudest voice. 3 days before the hearing, someone slipped a flyer under our gate. "We support Donna. Sign your name here." We kept walking to the mailbox, collected our evidence, and practiced calmness in the mirror, because this was no longer simply about a paint color or a lamppost. It was about the principle that you don't get to claim territory with sticky notes and self-made bylaws. On the morning of the hearing, the courthouse smelled like coffee and polished wood. Donna arrived in a power suit and a lawyer we'd never met before, a polished fellow with a practiced smile. I watched her posture. She was confident, almost cocky. She had one thing in her favor. People expect HOAs to win because most people don't want to fight. We filed in. My attorney, a calm, patient man who'd tried property cases his entire career. We walked up, evidence in hand, and sat a few feet away from Donna and her counsel. The judge, an even-tempered woman, reviewed the pleadings, then looked at Donna. There was a quiet moment where the whole room awaited a simple fact. Could the HOA establish jurisdiction? 3 minutes. That's all it took. 3 clean minutes where the judge asked one question Donna's lawyer couldn't answer, where the county map affirmed what our deed declared, and where the presence of the surveyor and the county registrar tilted everything. Courtrooms have a rhythm. Judge asks, attorneys answer, record gets made. Even a small civil courtroom holds a gravity that makes hyperbole fall silent. Donna's lawyer rose confidently, walked through covenants and clauses, and began to lay out a case for constructive inclusion. Basically, a fancy way of suggesting the HOA's norms applied beyond recorded lines because of community usage. It sounded good in the echo of the courtroom, but law isn't poetry. It's paper, it's dates, it's recorded filings. The judge listened, then looked at him, a little bored. Do you have any recorded amendment? Any county approval? She asked, blank faces. Donna's lawyer said something about ongoing use, which the judge noted skeptically. Use doesn't trump recorded property boundaries, she said. Is there a recorded document extending your covenants to this parcel? No, nothing. The judge's fingers drummed the bench. My attorney stood and began his portion, but he didn't need to be long. He handed the judge copies. The original deed, the county plat showing boundary lines from 1973, the survey we had commissioned, the tax assessment, and a notarized affidavit from the county recorder. Then I did something Donna never expected. I called witness 1 to the stand. Judge Martinez, our neighbor, rose and walked up. Not in robes, but plainly as a man who'd spent decades on the bench. He spoke slowly, deliberately. I reviewed both parcels. The county accepted no extension of HOA covenants to this land. He gave sworn testimony. The HOA had never submitted the necessary forms. The county had rejected an informal petition years earlier because it failed to meet statutory notice requirements. He explained how the land had been recorded as private, agricultural, and how the HOA's prior attempts were administrative only and not filed in the land records. The judge looked at Donna and then at the maps, then circled back to Donna's counsel. Sir, do you have an amended filing certified by the county recorded in the land records? The lawyer opened his mouth and closed it. No, Your Honor, we do not. 3 minutes had passed since the formal questioning began. In those 3 minutes, Donna's entire case evaporated. You could see it in her face. She shrank as the truth filled the room, not because the judge humiliated her, but because law is indifferent. It simply asked for proof and found none. Donna tried to pivot to homeowner complaints and community expectation. The judge interrupted. Expectation is not law, she said. Unless you can show recordable authority, a court cannot enforce non-existent covenants. The judge then read something that felt like a scolding, but was simply legal clarity. Courts do not substitute what should have been recorded for what is recorded. If you believed in extended authority, you had to formalize it. Donna's mouth was a small O. Her lawyer crossed his legs, looking painfully aware of his mistake. There was a hush in the gallery as neighbors shifted, their whispers tangible. By the time the judge rendered a preliminary ruling, dismissing the HOA's claim with prejudice, meaning they couldn't refile on the same claim, Donna's composure had cracked. She put her head in her hands, red across the cheeks, while her lawyer tried to whisper damage control. After the gavel fell, the judge ordered that the HOA pay modest court costs and consider mediation on neighborly communications. It was a small sanction in monetary terms, but huge in consequence. Donna's lawsuit was dismissed and her claim evaporated on public record. I watched her stand, once proud, now diminished by the weight of her own tactlessness. Outside, cameras and phones buzzed. The courthouse steps filled with neighbors who wanted to whisper congratulations or gawk at the drama. Donna left fast, her shoulders hunched, her practiced smile gone. She later complained about a biased judge, about politics, about anything but the fact she had no paperwork. We drove home slowly, the kids asking questions about how the courtroom worked. I told them what I always tell them: you don't need to be the loudest. You need the right facts and the good sense to show them. 3 minutes was all it took because ours were the documents that mattered. Courts don't settle neighborhood grudges so much as they set records. That dismissal with prejudice became a small public monument, a scanned PDF on the county clerk's site that anyone could read. It meant the HOA's claim was on official record as a failed attempt. Donna's position collapsed in other ways. The HOA board convened emergency meetings because neighbors were up in arms, some for our rightness, others simply embarrassed by the spectacle. Some members who once nodded at Donna's decisions began to ask harder questions about whether she'd abused the board's authority for personal satisfaction. Did she understand property law? Did she act on behalf of the community or her ego? Board ethics discussions followed. Donna's threats and bullying were recounted in black and white. A vote was called. She lost her presidency in a narrow margin, and the board requested new training on legal boundaries and county codes. Her tactics were criticized, and her clout evaporated under the weight of documented failure. For us, the relief went beyond paperwork. Neighbors who had quietly tolerated her notices started to talk openly. People who had paid fines they didn't have to now wanted refunds. Others asked for clear maps and official written boundaries. The HOA did an audit and found a handful of overreaches. A new board policy was adopted: no enforcement actions without recorded authority and prior county confirmation. It was a practical change born of embarrassment. Donna sued us in headlines of the neighborhood chatter for a while. She's fighting back, they said, but the county records told the honest story. When people looked, they saw the dismissal and the map. When they asked, we walked them through the documents. We didn't gloat, we explained. As for Donna, losing a presidency is a humbling affair, especially when you've built an identity around being the enforcer. She kept her house, but her influence shrank. She showed up at fewer community functions, and when she did, eyes tracked her with a new coolness. People still chatted amicably at barbecues, but a caution hung in the air. There's a difference between community service and a personal crusade. Months later, at a neighborhood meeting, a woman stood up and thanked us, not with fanfare, but with gratitude. "You made us all check our paperwork," she said, smiling. We were sloppy and too trusting. There was a round of applause. Donna sat at the edge, hands folded. I caught her eye and offered a small nod. She nodded back. We both knew the moment had been decisive. The ultimate victory was quiet. Our family could let the house age in peace without the clatter of notices. The kids kept fishing. My wife planted more lavender. I built a little dock for mornings with coffee. The county's map, the deed, the judge's ruling. Those were the shields that allowed us to live without someone else's idea of how our yard should look. In the end, Donna's suit taught a lesson about power and proof. It's easy to wield authority when people don't read deeds. It's harder when someone shows up with records, a witness who knows the system and the patience to let law do its slow, decisive work. 3 minutes in court, because we had the facts, made the difference between a bully's law and real law. If she ever writes about me in her diary of wronged presidents, I won't be surprised. But I'll keep my deeds in a drawer, the dock slotted into the water and the lavender blooming. And when the kids ask about the courthouse, I tell them, never confuse bark for bite. Paper is heavier than a clipboard,